Expression unius exclusion alterius, the mention of one thing excludes others. Where a list of words is available that is not accompanied by general words, then the act refers only to the things in the list. In Tempest v. Kilner, 1846, the court had to decide whether the Statute of Fraud 1677, which needed a contract to sell products, goods and services in excess of £10 in writing, applied to a contract to sell stocks and shares. No general words followed the list: goods, wares, and merchandise, so the court held that only contracts for those three kinds of things were influenced by the statute. Because stocks and shares were not mentioned, they were not caught by the statute. Noscitur a sociis, a word is known by the company it keeps. It means that the words have to be viewed in the context and translated correspondingly. It includes looking at other words in the same section or in other sections of the Act. In Inland Revenue Commissioners v. Frere, 1965, where the section laid down rules regarding interest, annuities or other annual interest were important words in the same sentence. The first use of the word interest alone might have meant any interest paid, whether on a daily, monthly, or annual basis. Because of the section's words other annual interest, the court resolved that interest implied only annual interest. The House of Lords in Bromley, London Borough Council v. the Greater London Council, 1982, deemed other sections of the Act. The question, in this case, was whether the GLC should implement a cheap fare scheme on their transport systems, where the paying rates implied that the transport system is going to run at a loss. In this case, the decision revolved around the meaning of the word economic. The House of Lords reviewed the entire Act, and in particular, another section which placed an obligation to make up as far as possible for any deficit. As a result, they determined that economic meant running on business lines and ruled that the policy of low prices was not legal because it involved intentionally running the transport system at a deficit, and this did not ensure running it on business lines. Presumptions. The courts might also make numerous judgments or conclusions about the law, but these are only the beginning. If the law clearly specifies the opposite, then there is no insinuation, and the assumption is rebuked. Key assumptions are: A presumption against a change in the common law. In other terms, until Parliament has made it clear in the Act that the common law has been modified, common law is supposed to remain. An instance of this occurred in Leach v. R. 1912, where the problem was whether a woman could be brought to bear testimony against her husband under the Criminal Evidence Act 1898. Since the Act did not explicitly say that this could happen, it was preserved that the common law presumption that a wife could not be compelled to give evidence was still in place. If specific terms were used to indicate that a wife was compelling, then the old common law would also not conform to it. It is now the stance in accordance with S80 of the Police and Criminal Evidence Act 1984, which explicitly says that one spouse may be made to give testimony against the other spouse in a crime of violence. B. A presumption that mens rea is required in criminal cases. The fundamental rule of common law is that nobody can be charged with a crime until it has been shown that they have the mens rea of committing the crime. Mens rea is the intention behind an act. For example, if someone has to prosecute a defendant for murder, they will have to prove mens rea and actus reus. If both are not present, the person will not be guilty of the crime. Mens rea is the intention behind the crime. For murder, it would be to kill or cause grievous bodily harm to anyone independent of the fetus, while the actus reus is the act killing. In Sweet v. Parsley, 1970, the offender was convicted with the administration of property used for marijuana smoking activities. The truth was that the complainant was the holder of the property that she had rented out, and the occupants had smoked marijuana there without her permission. She was obviously preoccupied with the administration of the property because weed was smoking here. However, because she had no knowledge of the situation, she had no mens rea. The fundamental problem here was whether mens rea was needed. The Act did not state that there is any need for knowledge of the issue. The Supreme Court held that she is not guilty because the inference that mens rea was needed was not disproved. C. A presumption that the Crown is not constrained by any law unless explicitly stated in the law. D. Presuming that the statute does not extend retrospectively implies that no Act of Parliament may refer to past events. Each Act would usually only extend from the day of its entry into force.